Thank you for tuning into the Punchline podcast. My name is Seretse. As you know, always we gather here every week on Thursdays or any other day of the week to bring conversations that matter to you. So today in the studio, I thought that I will make something very, very, very special that we have never done before, that I want you to really appreciate, that I want you to really go down and follow each and every moment of the conversation. Basically, I want to go into one of the biggest stories that has ever happened into the country. We start right from where it began. We unpack it, we go through the tentacles, and then we try to understand how it ended and what is the status quo. One of these issues, as you know, is called the National Petroleum Fund case. Some say saga, some say case, some say scandal, some say whatever. I don't know what these words mean, but for me, it's much more like what I want to bring to you is for us to understand the story behind the news. So for the first time, we unpack Botswana's biggest national financial scandal, the 250 million Pula National Petroleum Fund saga. From secret Israeli deals to courtroom dramas, political interferences. But today I'm with Kgosi Ngakaagae, who joins us to break it all down. This is the story behind the headlines.
Thank you, my brother.
So let me welcome to the studio today, Kgosi Ngakaagae, aka Mr. Silver Fox. How are you, my brother?
I'm fine, my man. How are you?
I'm great. I'm great. It's been a while since and then we come and talk about things that matter to our society, because you are pretty much doing a lot and it's really hard to pin you down. And I'm happy that today you finally found time to come and join us. I hope everything is well on your side.
Pleasure to be here, my brother.
Yes.
Everything is well on my side.
All right.
Sure.
Can we check your pulse first, then your health check before we get on this roller coaster? MRI or the medic.
The good thing is, like, last week I was with my doctor. I had gone for my regular checkups.
Yes.
And, my health was significantly better than it had ever been. So I think I can ride along.
Okay, I saw you hiking as well.
Yes, I did hike.
How many kilometers?
The last weekend we did 22. Yeah.
Yeah. Okay, that's nice. Why do they call you Silver Fox? Let me start there.
Could it be the gray beard?
75. Well, it's probably coming from the ladies sector, not the men's sector. Leader,
sure.
A week ago, you and I were at the men's conference at your farm, Lotlakane West. Please update me, because I know what was happening there. We did amazing things there, but I would like to get your experience and what you took from there and what you think really needs to be done given the initiative that the team has started.
Oh, yeah. Wonderful experience. And one of those times when you feel you're doing something that's really beneficial to society, or that could potentially be beneficial to society. When you think you are pursuing a cause that's greater than your personal interests.
Yeah.
And it was such a pleasure to have, everybody there, the whole team that put it together. It wasn't just me, it was a whole lot of guys, including yourself, and all in the name of the boy child, and trying to shape a better boy child for tomorrow. A boy child who can live with their sister in peace, a boy child who doesn't rape, who doesn't do funny things, and, and trying to be responsible and fill in that space as men, So, there were a whole lot of takeaways from that. We had the boy child. We had conversations.
Yes.
We even had more of a panel discussion
where
two boy children were represented.
Oh, there's powerful
and
stories.
They said some powerful stories, the kind of experiences they go through, and a whole lot more. We're looking forward going we're looking going forward to holding that kind of dialogue on a regular basis and actually spreading out this whole movement to all the
different regions of the country,
and reaching out to every boy child there who needs to have a voice, who needs to be heard, and who needs a shoulder to lean on. But it's not just about the boy child, it's also about men, because we just go through so much. In the end, the idea is we can have a better society where the boy child and men live at peace with the girl child and women. And we have all citizens pulling together towards the realization of our national goals and aspirations. And that is really the whole idea. And
I was there. I listened to conversations, and someone says something really powerful in one of the groups we were talking, saying, I want to raise a boy child who you can feel safe leaving your daughter with. I thought that was powerful. But that was the men's conference. Obviously, we are looking forward to the next year and how the year will unfold with other initiatives again.
Oh, certainly. We got so much coming. We had a meeting of the leadership of the movement last week. We have so much coming. We'll be consulting, obviously, with the members for their input, after which we're going to draw a full year calendar that's going to guide us through 2020, the remainder of this year and the coming year. And we are looking forward to some really exciting moments.
Right.
We hope to move beyond talk to action. We hope to be impactful and to bring about the needed change in the country. Yeah.
Brilliant. So today I decided that I'm coming to the studio, but there were no bars blood. Today I'm saying no shoes worn.
Let me get ready.
I've removed my shoes so that if ever the temperature gets too high, I can breathe and keep up. I'll start with this one. There is a word called advocate, lawyer, and attorney. I want you to break me down these three titles so that we never get to ask or confuse this definitions again. What is an advocate? What is a lawyer? And what is an attorney? And what's the difference? And at your level of expertise, some people confuse you of being an advocate. And why are you not one?
All right. Let me start with lawyer.
Yeah.
I became a lawyer when I graduated from law school. Okay. I had a legal qualification. Yeah. I had an LLB. If you have an LLB, you are a lawyer.
You're a lawyer. Yes.
Yeah, because you are schooled.
Whether practicing or not practicing, but you have it.
You have a qualification. You are a lawyer. You've qualified to be one, and you can be called a lawyer.
Okay.
You may choose not to do the courts, or you may choose whatever else you may choose, but you are a lawyer. An attorney, you only become an attorney when you have been admitted to practice law before the courts.
Oh.
That's when you become an attorney.
Yes.
There is a process that you go through. You must be found to be a fit and proper person. And there is a process that you apply for that. And you have to convince the court that
including not being bankrupt.
Usually they don't emphasize much on money at that stage because, you're starting and all that. But they emphasize a lot on character. They emphasize a lot on qualification. They emphasize on whether you have completed your pupillage, etc., etc. But once you have that admission, you are given a practicing certificate which qualifies you to call yourself an attorney.
Okay.
Now, once you're an attorney, you can decide if you want to be admitted as an advocate. Okay. And generally, the difference is when you are an advocate, you have to be briefed by an attorney. The matter comes to me, let's say I'm an attorney, and I think it requires the attention of someone who has more time and perhaps even more experience to deal with it. I would find a suitable attorney to do that. Now, you're going to discover that as attorneys, especially in our market, we operate on a high volume, low fee.
Higher clientele, low fee. Yes.
Yeah, I mean, like our works, high volume, low fee. So go regard the cash and carry thing. High volume, low fee. But you'll discover that attorneys, advocates generally, operate on low volume, high fee. An advocate would have maybe 4 cases in a year, which would gross 3 times what an attorney has made over the same year. The attorney having handled 50, 60 different cases. Why? Because they've got much more time, or they give much more time to cases on the basis of their complexity. Most attorneys qualify to be advocates, but the market, the local market is such that you would starve if you... I qualified to be an advocate more than 20 years ago, but I chose not to be because I would starve. So are there many other attorneys.
So when you are an advocate, you can't take attorney work.
When you are an advocate, you cannot solicit for work from clients directly.
You only solicit from another attorney.
It's only another attorney who can instruct you.
Hey, but
the client would come to me. I would consider that exactly. So now, if I were to move to be an advocate right now, you can imagine what's going to happen. Probably few guys who would think I have any knowledge that surpasses theirs to be able to say, you know what, let me pass this on to host. They would rather do the work because they need to get paid. So being an attorney is for the most part a business decision as opposed to whether you qualify or not.
Is it not also because of the level of cases that we have as a society? Because I can imagine if I mirror to other developed countries, you have advocates dealing with counterterrorism, cases that are of a bigger magnitude than when we are dealing with divorce, theft, all of that. Is it not because of the level of the cases that then you receive?
Yes, certainly cases differ in complexity. It's not even about the type of cases.
You can't be an advocate and deal with a guy who stepped a girl.
No, you're not going to find an advocate dealing with a common assault
They
case.
deal with bigger cases
not
like
that
we've seen
really
with Gerinel at that level.
Not that there's really any legal exclusion. Not that if an advocate rocked up in court and he was representing someone charged with use of insulting language, that would be illegal. No, it won't be unlawful. It won't be wrongful in any way. But based on what the calling of an advocate has come out to be, it would be a very bizarre thing because that's work that is generally left to entry-level lawyers, or attorneys who are still trying to grow up in the profession. So,
and by the registrar of courts bill of costs level,
they charge much higher.
Then you'll be charging too much for a insult type of. Okay.
Yeah, you'll be charging too much for common uses.
Yes.
Precisely.
Okay. Yeah. I'm sure. Maybe I hope that we all get it. I think I do understand you, and now I know how many advocates do we have here. I know Advocate Boko, I know Advocate Pilani. I know
a few guys. I think there's Advocate Boko, Advocate Pilani. I know there's a gentleman Advocate Ramidi. There are a few.
We don't have a lot.
Not many. No,
even white practitioners. I'm not
an
sure.
Advocate Kibona.
Yes, Sadiq Kana is also an advocate. Yes.
Exactly.
I was trying to say when I'm tapping into seasoned attorneys like your Armstrongs and all the likes. Unless I don't know, I've never seen the word advocate.
No, they are not advocates.
They are just attorneys.
That's why I tell you, it's more of a business decision. These guys, I can walk to the High Court today and be admitted as an advocate tomorrow if I wanted.
Yes.
And there's really nothing that would stand on my way to doing that.
Okay.
It's there for the asking or for the taking.
Okay.
But from a business perspective, it doesn't make sense to me because I'm going to have to sit in the office and wait for attorneys to instruct me.
Okay.
when I could be sitting there being instructed directly by members of the public. And that's why these big law firms, the guys, the proprietors or the guys behind them, who are much more experienced than I am, remain attorneys. It's also a business decision. It's also a
I would like to underline the word business decision for later use. So let's go into why we are here. The National Petroleum Fund case. Maybe let's start with the genesis of it. Let's start with understanding the basics, right? Because we are going to unpack it all the way to where it is now from 2018, right? 2017 when the 2017 when the first charges first emerged. But before we go there, let's try to understand the simple glossaries. What was the National Petroleum Fund originally set to achieve?
Okay, practically, it was to cushion the general public from the volatility of the world oil markets. You know, the world oil markets are such that there's been a single act of terrorism. It would be very difficult for the public to keep up with that kind of volatility. So the National Petroleum Fund, in a kushina, you know,
the market stability of the market.
Yes. Then you know that you can still procure oil from the international markets by using the Goro supplier, the whatever demand that has resulted from that.
So that you don't offset to the consumer.
So that it doesn't, the oil, which is such an essential commodity in people's lives on an everyday basis, is not left to the rigidities of the market forces. Because the public, for the next maybe a month. And then after that, 2 days and then you know, the markets are too volatile to be left jacadins. But also, in a through it, address the country's strategic interests regarding the oil sector. For example, depending so much on oil. Literally, I mean, the only reason why I managed to get here in the last couple of minutes or maybe an hour, I had to fuel my vehicle. Now imagine if it were to happen, for example, that there would be no supply of oil for quite a while. Maybe when Israel has bombed Iran or whatever might have happened, or there's war in the middle. Strategic oil reserves. And so it was also for long-term and medium-term vision with regards to oil security. So in a say the price, that was the other.
To have more reserves as well and whatnot.
Have more reserves.
I like that. And then a lot of us in naivety knew that there's something called NPF. We generally didn't know what it means. I'll speak for just an ordinary most of us. Until there was this scandal where Bakang, Seretse and others were accused of having misappropriated the proceeds of the fund. But let me start here. When did you first hear about the irregularity involving the National Petroleum Fund?
It was on the 3rd of December 2017. Actually at 11 p.m. I was just getting ready to sleep and I get a call. And I get a call from the family of Bakang,
yes.
And I get a call from them to say there's a situation in Wanarona or is in police custody or DCC custody, actually to be more precise, the DCC. And can you check out what the problem is and get back to us? That's when I got the brief. And I started moving. I was running around all night trying to locate them and all that. Took 2 days to be able to get a full picture of what was happening. And because but that's a story for another day. But to answer your story, to answer your question directly, I first heard of it on the 3rd of December 2017.
I remember because I was at Gazette and we were one of the first to publish the breaking news that the comrade has been taken in for questioning. Don't dodge that question. You say they were moving them around when they had now confirmed you as their attorney in representation. What exactly do you mean that they were moving? What was happening?
They would not allow us to see them. In law, or in terms of our legal system, you're entitled to a lawyer right from the point when the police look at you in the face. Before, the moment they say, you are entitled to insist on assistance by a lawyer, and you are entitled to insist on assistance by a family. Because even at that point, you can simply say to them, I'm going to exercise my right to remain silent. I'm not going, if you want to put me in because you have that dispensation, but you can put me in for 24 hours, go ahead. But what they cannot do is force you to speak. And in any case, it always makes sense to speak only after you have consulted with your attorney so that you do not risk yourself.
Yes. So when this is happening, obviously it's not new to you, knowing the usual modus operandi of our security sector at the time where they will move people around. You get the first call, you arrive, you find that your client is not there and the client is being moved around. What first comes to your mind?
Look,
before you even hear what the issue and the content is, and what first comes to your mind when all that?
What first comes to my mind is, why are they preventing me from seeing my client, or why are they denying the client access to an attorney? And it could be a variety of reasons. The client might have been tortured and hurt, and they may not want the attorney to see them because they'll be in trouble. That's one possible reason. The other reason might be they may be trying to milk the client of all information before the attorney gets there, such that by the time you come in as an attorney, you are virtually close in the stable when the horses have bolted. You know what I'm saying? So it could be for their strategic investigative interests. It could also be because they have committed offenses and they don't want you to find out. And
so within those possibilities that you are giving, before we move on, ultimately, what did you find out? Why were they moving?
Certainly, they wanted to milk the clients dry because the clients were not tortured in custody. Certainly, they wanted to milk the clients dry. You know, when the client is there and isolated and alone and scared and all that, it's easy to force the client to confess, even to things that they may not have done. But, you know, you get a lawyer in, the first thing he's going to do is tell the client, this is how far you go, this is how far you don't go, and all that. And the law enforcement guys don't like that because then they've got a totally different ball game in their heads. They like it when the client is alone and unprotected.
And they can simply
pick him out, you know, his easy prey.
So ultimately then you locate your client, right? You get the full brief of the story and what happened. The information that comes to you as the attorney, what happened? What was the specific deed or transaction that triggered all of this?
Essentially, it's quite difficult to say any particular instance triggered it. As early back as perhaps August 2017, I wasn't even involved in the case at that point. there had been complaints. I got to know. There had been complaints that perhaps there had been some anomalies with the National Petroleum Fund and how funds had been handled. And the complaints seem to come from different sections. My client would insist that they came from their competitors in the industry. You know, my clients were or happened to be perhaps the only fund investment or management company that was 100% Botswana owned. That was basis points quarry capital. And that's the Bakang Seretse outfit. The market had been dominated 100% by
foreign interests.
Foreign interests, you know, mainly South African, Zimbabwean, and Indian interests. But this new kids on the block come in, and within a short period of time, a year to 2 years, they are managing an investment portfolio of around 7 billion pula, with more coming their way. And that's a large chunk of the market, because all this business could be going to the usual
foreign interests.
Foreign interests.
But before we move, how did then they end up having a bigger piece of the cake where it was an anomaly?
Look, they had been...
Was it policy changes? Was it...
No, there were no policy changes. They had proved themselves in their previous occupations. They were working for fund or investment or management companies like Go Investec, etc., etc. So they already had, it's more like one guy leaving a blue chip law firm to set on their own. But already the guys he's been working with in the industry know him to be a very capable guy. So he has a reputation, he's got goodwill already that they are living with.
So they are able to walk away with a certain portion of clients.
Walk away with a certain portion of clients, or a certain portion, even if they don't take the whole client, a certain portion of the business.
Yes.
You know what I'm saying? So that is how very quickly, and if they excel, like maybe in a year or two, word goes out in the market that they have actually that there are new kids on the block and they're doing so well. So you get more money going their way to manage or to invest. And that is precisely what was happening.
So is it that where now they gain the interest of the Directorate of Intelligence to say, maybe we can work with... How did they get to end up working with the Directorate of Intelligence?
That came much, much later. Because as they were managing the National Petroleum Fund, there's generally no interface between them as fund managers and the DIS.
Yes, in the scripts, yes.
Yeah, there's generally no point of interface. It was more the DIS who were interested in the fund from outside. They wanted a part of the fund. They wanted some money from the fund. So they found themselves, so they started, knocking, at the doors, chipping, trying to see what they can get out of the fund for right or wrong reasons. I have my opinions, for all the wrong reasons, I would say. But they would insist that, it was for the right reasons. So they wanted to chip at this cheese. The DIS were a bit cantankerous then, I would say. They had messed up the disaster management
it's common knowledge.
This is common knowledge.
Yeah.
So these funds, the DIS saw them as easy picks. So they targeted the National Petroleum Fund. And when they got there, obviously, because my clients are the fund managers, that's when they came into contact with my clients. Not directly with my clients, but through their dealings with the ministry that had contracted by clients to manage the fund. Yeah.
The word targeted, I want us to clarify it later as you are breaking down the story, because I don't want to put the cart before the horse, because I would like to understand later when you break it down to say exactly you account for that your clients were targeted. What exactly do you mean? Maybe I want us to go through the whole, because now those are your conclusions now at the end.
Precisely.
You feel that they were targeted. Maybe right now, let's say, I don't know anything. I just want to understand how it all went down.
Yeah.
Then they find themselves in that position where the intelligence is saying, look, let's dip into what you have been borrowed to hold for us as the public, to divert it for a certain type of use and reinvestment for a certain type of purpose, right? You represented the defendant, Dager,
yes.
which is, the major defendant was Bakang, Seretse,
correct.
And others. What was your first reaction when you learned of the charges? What were the charges, Kana?
At first we had, there were like 2 charges.
Yes.
And they were money laundering.
Yes.
Charges and obtaining by false pretenses.
250 million.
2 charges. Just
yes.
That was the first time we saw a charge sheet. Was practically on the 5th of December, 2017, when the DCC had kept them in their custody for at least 2 days, and the 48-hour dispensation that they are allowed to detain people without a warrant.
Yes.
Had expired. So they had to go before a magistrate. And you can't go before a magistrate to ask for further detention without a charge sheet. So the first time we saw a charge sheet was then on the 5th of December 2017. And it had 2 counts. One count being of obtaining by false pretenses and another one being for money laundering. But subsequent to that, the charge sheet somewhat expanded until we had, in some instances, around 120 counts in one charge sheet. And then we had around 189 counts.
I remember, we couldn't fit them on a front page. Yes.
The charge sheet just kept ballooning. Each time we went to court and we were hoping for trial, because we were getting tired with just being in court without actually making any progress. When we got there, the prosecution would present another charge sheet with more charges, with the result that would go straight back and look, we are now 2 years into the case, but you are still having the prosecution amend charges. It's time at which you ought to be probably being at the 6th or 7th prosecution witness, or maybe the 20th prosecution witness, but you're still marking time around the charge sheet. And it came to that point where I think after the charges had risen to around 120 thereabout, and they wanted to increase the charges, I think, to around 189 thereabout. We then objected and we said, no, it's got to stop. We got to go to trial now. Because the next time we come again, it won't be 189 charges. It's going to be 259 charges. And we're going to be playing this game forever. And in the meantime, our clients are suffering anxiety and so much. So we objected and the magistrate agreed and said, no, look, I'm not going to allow any further amendment of the charge sheet. So we were stuck at around about 120 charges. And what they did is the charges they wanted to add on, they opened another case separately and charged them as a second criminal case. So we had 2 criminal cases now running parallel before
which was courts. Money laundering and then obtaining by false pretenses.
Most of them were money laundering. There were charges obtaining by false pretenses, generally theft charges, stealing by agent, etc., etc. Those are the kind of, or cheating the public revenue. That was another charge. There were all those kinds of charges.
So, what was your client's reaction to the charges? And who else was charged initially when it started?
When it began, there were like 3 accused persons. It was Bakang Seretse, that was on the 5th. It was Bakang Seretse, it was Kenneth Gereka. Bakang Seretse was the man behind Basis Points and Quarry Capital.
Yes.
Or at least, I assume, the main person. There were others, certainly.
Kenneth Gereka was the director of energy at the time.
Kenneth Gereka was the director of energy at the time. and being the director of energy, he was the key person in the Fund Management Committee, that is the National Petroleum Fund Management Committee. So the suggestion was that they had conspired with him to defraud the fiscus. And there was a lady who had been charged. I think her name Botho. Yeah, Botho Lebur.
And then there is a name I recall, Dr. Bakang, who was a PS at Minerals. He was in charge, right?
No, he wasn't charged.
I remember there was a back and forth question that there is a whole signatures of letters. There are two individuals who haven't been charged. That was Dr. Bakang and Colonel Isaac Kgosi, who was the director of the DIS at the time. They were not charged, and you are dealing with this. But my understanding was they were part and parcel to whatever that transaction was, which we'll get into. What was your reaction to this?
It was somewhat crazy, quite honestly, because, look, you have these guys here, and I'm saying this at the most objective level. You have these guys here, and they are being charged with all these kinds of offenses for having embezzled 250 million belonging to the public or to the government. And obviously, you would want to investigate how precisely the charges are formulated. I mean, where the embezzlement practically happened. And then you discover that, no, the money was in fact under the direction of the government itself the entire time. And it was not even directed by Kenneth Gereka. The money was being directed by the minister. It was being directed by the permanent secretary. For example, the person who gave clearance, whose signature gave clearance for the money to be used by the DIS away from the initially intended purposes was the permanent secretary himself. So we were stunned to ask, but if the PS is the one who signed off the money to the DIS, how could Bakang be guilty of embezzling the money? And if the money was spent precisely in the way that the DIS said it should be spent, in writing, authorized by the permanent secretary, what does Bakang have to do with it? And these are the kind of things that, I was quite confounded by all that. So this is where, we were then saying, no, look, let's pause a minute. If our client stole the money and the money was signed off by the PS, if at all they were part of any theft, then the PS ought to be in the box as well, ought to be in the dock as well. And if the money was spent at the instance of Colonel Isaac Kgosi, may his soul rest in peace, then he also ought to be in the box, because they were the people who were directing the money.
Yes, I remember that argument vividly. Before we go into the next, let's now try to understand exactly what were these signatures. What was the transaction about? What exactly were they trying to buy, and what was happening? What was the transaction really about? Which triggered legal alarms such that what was DIS trying to buy? What has the PS signed for? And what is it that became an irregularity that maybe the other parties should have not done? What was being procured?
The initial raison d'etre for using the money. What the DIS simply said at first was that the construction of strategic storage reserve, which fell within the reach of the
National
Petroleum Fund. I mean, it was a legitimate purpose to which funds could be properly NPF funds could be properly applied, strategic storage reserves. The DIS said these reserves are a matter of national security. And the DIS arrogated themselves the lead role in the construction of such reserves. Because according to them, they were a matter of national security.
Yes.
Because according to them, those were a matter of national security. So they could actually take the project of constructing the storage reserves from the people who had the ordinary mandate to do that, being the ministry itself. And it was Dr. Bakang's signature that authorized that they could, that they could actually do that. Now, having won the mandate, it wasn't even winning the mandate, because then the DIS only told you what they wanted to do. And you just had to play. You just had to play along, pretty much.
It's not your money anymore.
No, it's government money. If those guys came then and told you, this is a matter of national security, and we are the people behind this project, and we're going to take it over and run it because on national security reasons, you would find yourself in a very difficult position to say no if you were a civil servant.
Yes. So the diversion was to say, no, before the diversion, the idea and the project was to say that we are going to build strategic reserves and we are going to take money from the NPF.
Yes.
That was the initial.
There had been an intention to do that. Before the DIS even came in. But the DIS came in and now we are taking it over.
Right.
Yeah, we are taking it over because according to us, it falls within the national security, interests of the country. Yeah. And we are a national security, institution.
Okay.
So there weren't alarm bells, or much in terms of alarm bells at the time, until the point where the DIS wanted to directly procure the companies that would actually implement or construct the strategic storage reserve. PPADB said no. PPADB refused. They had the guts to say to the DIS, no, we are not going to allow you to directly appoint people that are going to do this construction. It should go for open tender. And the DIS were resisted, I should say successfully, because they went back with the PPADB refusal. When the DIS came back,
the money is still there with Bakang. It's not
the money is still there with the National Petroleum Fund.
Oh, with the Petroleum Fund. Okay,
it's being managed by Bakang and Company.
Yes.
Precisely. What then happens is they then come back after PPADB rejects their proposal. Some time passes, maybe weeks, maybe a month, I'm not too sure. And then they come back to say, look, there has been a review. All these things are documented. I have all the paperwork. They then say, look, what has since happened is there has been a reprioritization in terms of national security interests.
That's where it starts.
National security interests. More like the strategic storage reserves have fallen down the priority list. There were other threats that had emerged which had taken priority, among them anti-terrorism, human trafficking, poaching.
But we still want that money,
etc. And this prioritization has led to all these new priorities need to be the fight to tackle all these national threats which have emerged needs money. And we think the money that can help in this cause is that money which was initially intended for strategic. Now, the money is going to be...
That's where now all the drama
begins. The pandemonium starts. But like they say, there's always a calm before the storm. Because at the time that they are saying this, it's internal dialogue between the DIS and the ministry. Remember, this dialogue is between the DIS and the ministry. Bakang are not involved. But their duty is they are outside. The money belongs to government. So they're not part of that conversation. You know what I mean? So the conversation is between the DIS and the ministry. The paperwork is there. So the ministry itself, through Dr. Obakeng's signature, actually, this is where Dr. Obakeng comes in. The ministry itself, through Dr. Obakeng's signature, authorizes that the money should no longer be used for strategic storage reserve, but for the new need that the DIS have expressed, stemming out of the reprioritization of matters or challenges that are considered to fall within the national security sphere. So now the Ministry of Energy, Green Technology, Energy Security, Minerals, Green Technology and Energy Security, I think that is what it was called, now says to Bakang, we have agreed with Kgosi, or with the DIS, for my dear or those strategic storage reserves. I go this new national security threats.
Yes, before we get into that, it's quite interesting. Are you following? That's quite interesting. So now tell me, what were these national strategic security interests? Was there a document? Was there an investigation? Was there what were they in specific? Because we can't just say National Security Acts in blanket.
The DIS had I have the document. The DIS had stated as part of their justification that in their continued assessment and reassessment of national security threats as they emerge from time to time, some threats had jumped up the list and had asserted themselves as deserving more attention than
that was in 2017, or we had now moved to 2018.
No, these things are happening in 2017. Long before.
Okay, I'm trying to map who was in power at the time, because I'm trying to also understand the type of threats and securities that that were there. Okay,
anti-poaching. Poaching, anti-terrorism, money laundering, all those.
There was a whole cocktail of what they were.
Yeah, human trafficking, etc., etc.
Okay.
So, fair enough. Remember, Bakang are just the agents. They don't own the money. The money is owned by the government of Botswana, by the ministry. So when the ministry says, as an agent, you don't have a word in that because it's not your money. The government can decide to do anything with its money.
But what did they advise? Because they also, if you're holding the money, your job also has an advisory role into it. Not to say that they will agree or whatnot, but what did they advise? I'll let you into something. It was quite bad because initially, the suggestion that had been made by the DIS had been they needed upwards of 600 million to address the challenges. And 250 million was too small.
The 250 million figure came on account of the fact that the functionaries were like, look, that would completely deplete the fund. And then the public would be left unprotected against the volatile oil markets. Why don't we give you the money, Gadi Trench? Let's start with a smaller figure, and then a
smaller figure,
250 million. You know what I mean? Yeah. And that is exactly
just kill you.
And that is exactly what happened. That's exactly what happened.
So they are receiving these instructions as agents.
Yeah.
what they have to act on it. They don't advise, or they advise and their advice is superseded. And
no.
What was the exchange? Because now they find themselves, now they have to answer for having been the responsible guys and the caretakers of the funds. I'm just trying to understand whether they had the opportunity to advise, or it wasn't their role really to advise.
There could be a point where they could have advised, and they did advise. Remember, the first use for the money was for strategic oil reserve selling, isn't it? Sense. And that was well within the fund's rate
and the principles of the fund.
The objectives of the funds. And that's why they could say, the fund will be depleted. Why don't you, as government, at least take so much, and after a while, more so that all these funds are not there sitting in some account. They've been invested all over the world in markets, in offshore markets, etc., etc. So to actually get the money back, the 600 million or 700 million, it was around 700 million, you'd have to disinvest from those and get the money straight back so that the money could then be applied to whatever purpose the DIS needed the money for. And that was just going to be a mess.
So just to divert a little bit.
Just to answer your question, directly, the point where they could not advise was when the DIS now needed to vary the use Yamadi from strategic storage risk. Because when it comes to national security matters, it was a conversation exclusively between government and the DIS. So the only thing that they get in the end is an instruction from government as to what to do. And when it's national security and all you are doing is managing a fund, you can't say to government, put your national security interests last. That's not a conversation you're going to have, because that's a totally different thing altogether. So they couldn't advise in that context, precisely.
On that. So, Madam, do you have a question?
Yes.
Yes.
We're good?
Yes.
Right, so you were talking about the reserves that were built. We have seen silos in Ratisa. What's your take on that?
Silos, like with regards to the construction of the strategic storage.
That's cellular storage.
Yeah, the cellular storage. Yeah. It's a project delayed. Probably, look, this project, its inception preceded the request the DIS to use the money. It was there before. It was there. It had been conceived by the ministry itself. The DIS simply chose to pick it or to take it away from the ministry. So the silos and all that, those were well intended, quite honestly. There was absolutely nothing wrong. Because at the end of it all, given the volatility, you better be having your oil at home all the time, such that instead of having to spend money to cushion the public against markets, you can simply use the oil that you have to ensure that the supply is steady. And whilst you are using your oil that you have at home, the markets could be correcting themselves on the other end. So there was really good principle behind the
You see, I like the question because I have a gut feeling that it's going to be answered at the end of this, because we are going to be sitting on a pile of mess when we end this conversation of unachieved goals. Basically, maybe we will see how it unfolds. I want you to close this. You remember, what does the ordinary person usually do?
The ordinary person.
So basically, this is what the DIS did. It asked for funds for a proper specific intent. A may bounce, or for whatever reasons we don't know yet. So that something else, which is where now the violation of the policy and the principal of the fund now raised red flags. Am I right or am I wrong?
Let's not mince words here.
Okay.
You know, part of the problem with us as Botswana, the DIS changed course because direct procurement was refused. That's the reason why they changed course. Because this whole reprioritization stuff came upon PPADB rejecting direct procurement.
Are you implying that even if PPADB had given them what they wanted, direct appointment, they'll still have not built the
They would have built it.
But then why change course if you meant, well, do open bid?
Man, look, make your conclusion.
Or other interests.
You want money from government, and government is ready to give you the money. And then you say, I want to spend this money by making a direct appointment. And the responsible agency says, no, you can go ahead and build the strategic reserve.
So the idea wasn't not to build, was
no,
what
the
meant
idea,
to
they
was
were
to have a
going to
middleman.
They wanted direct procurement.
So that it can go to someone.
To someone. So there was an ulterior motive. That's why I'm saying
they will probably still have built the storages.
They would have built
the
it.
The chunk of the beneficiary would have been.
But through a selected or an identified individual.
So then how does Bakang get caught up in this?
That's why we were coming to. PPADB says, no, open tender. Now, open tender means that it's not going to be the DIS adjudicating who gets the tender. It's going to be the PPADB. In which event, now it's anyone's game. You can win it, I can win it, anyone can win it. And that's when the variation now comes in to say, no, let's now rabatela Sicily. Now look at Hore Sicily, Serai. Anti-terrorism, anti-laundering,
Yes,
those are now within the national security space.
Yes.
You see what I mean?
Yes.
Those are now within the national security space.
Yes.
Now, if you battle my idea for anti-terrorism and for money laundering and like human trafficking, those are not tender matters. Essentially, you are simply sending the money to.
Let's move quickly then. We've established the issue, the variation, and the whole national security thing. Remember, at first there was basis points. When does Kulaco come in, and when do the Israelis come in within this whole discussion now?
Okay, fair enough. This is how Kulaco comes in, and this is how the Israelis, come in.
It's still the same fund we are talking about.
Now, this is what's happening. When the DIS say, ama dia nong a ekwa le gore menta ba dumala na gore madi a go dithobolo go reka dithobolo and dio tse tsothetse le go dia go combat bo terrorism. Bo Bakang go NPF are given an instruction on how to spend the money towards those purposes. Duela ma Israel kwa duela mbosi mama kwa duela njalo.
Who's giving them the instruction?
The DIS themselves.
Yes,
all the paperwork is there. The specific directions signed by Rekhos.
Yes.
May he so
I remember the
exactly. The paperwork is there. Yes. So Bahiwa, these instructions. That is the point where they say no. Our mandate is limited to the NPF and its administration. When you get us involved in payments about anti-terrorism and money laundering, you are taking us outside it's out of scope, for lack of a better word.
Yes, and we run a risk of being blacklisted in the financial sector.
We are in a completely different space. Now, what we would do is, if you want us to manage this, because these are transactional services, we can only come in as a different company. Now, that is when Kulaco comes in. Because basis points and Kore Capital are managing the National Petroleum Fund. But these are transactions which are completely out of scope and unaligned to the mandate they are contracted for. So they are saying, no, we can only handle that through another company we have called Kulaco.
Why did they have to say
It's a transactional advisory services company. You see what I mean? And then
To keep the conversation.
Hey, now, the DIS write a letter specifically to Kulaco. Not Bakang Seretse, Kulaco. To say, Kulaco administer the money in the following manner. Kulaco was brought in by the DIS letter itself under Kgosi's signature. So that's how they came in. And the letter says, my dear, aduelwe maIsrael.
Where was Kulaco getting money from?
Who's it?
Kulaco.
No, Kulaco, what would then happen is basis points would pay the money
to
Kulaco.
So Kgosi wrote 2 letters. He wrote 2 basis points and say, pay Kulaco, and then he instructed Kulaco what to do with the money.
No, this is what happens. Kgosi, okay, the ministry itself says to Kgosi, you have the money. The ministry says to Bakang, use the money towards the purposes identified by Kgosi.
By the DI.
And that's when
the DIS will give you instructions.
Exactly, the DIS will give instructions.
Okay.
Bakang, no, this is completely outside the mandate or the contract.
So horror ministry wa itsomo.
Ministry one uko handle madi to Kgosi. Now DIS yano idila le Kulaco.
Ke madi a rona no.
Ke madi a
tell you what to do.
We'll tell you what to do. So ba kwalla Kulaco le kwalo. Le address it specifically to Kulaco. Not core capital, not basis points, to Kulaco. That's how Kulaco comes in. Mele kwalo la teng hapelare. My dear, I administer njana towards Dignia Systems International, Israel. Remember, at that time, Bakang habaitsi le gore Dignia Systems ke. Dignia Systems ke lina le letanga ka DIS. Ke ba le gore DIS ba dila le bone ba procure ko go bone, etc., etc. So that's how Kulaco and Dignia Systems or Israel came in. But both Kulaco itile ka bo Bakang. Dignia Systems city like a DIS.
Before you move on, I understand the letters and the conversation. How does money then move from basis points to Kulaco? Was there an instruction or how does that happen?
Exactly. Now, ba DIS. Remember bo Seretse barile. Since this does not form part of the contract, NPF is completely different services for which you are engaging us. We can only function through a different company. It is the company to handle transactional services. So, ba transfer madi to the transactional services company, in particular Kulaco. Because basis points is not for that. Basis points has been contracted to manage the NPF fund. But transfer Lamadi to Kulaco in agreement with the ministry and the DIS, so that the transactional services company can handle all the demands of the DIS, which are now outside the Ministry of Energy's portfolio
as well.
You see what I mean?
So at some point, core capital basis points fall off the rail and the ministry follow Kulaco.
Exactly. Bale basala le mandate wa bone.
Or different.
Kulaco, Kgosi, but remember the authorities from the ministry. And then DIS Dignia Systems International, Kulaco. These are the people we are going to be dealing with. So, Bo Bakang are thrown into completely different space. And because these are transactional services that don't form part of the contract, Yahoo Manager NPF, they say we are going to levy a fund for our services as Kulaco, performing transactional advisory services that are outside our contract, which had specific terms regarding what they had to do or not to.
You are talking about their fee note.
Their fee note.
Which was it 69?
No. They said our charge is going to be 20% of the amount.
Yes.
This communication is addressed to both the ministry and the DIS.
Because now
the letter is there. And this is long before.
No, I remember the letter. And
this is long before the money even leaves the National Petroleum Fund while the discussion is ongoing.
And before the case itself.
Exactly.
When the conversations were being
When
had.
the conversation was, the letter is there. And this is exactly where the Court of Appeal said, look, this is nonsense. These people told you what their charge was long before the money even left the government coffers. And they told you precisely how much they were going to charge you. You had every reason, every right to object if you felt that their charges were preposterous or were unreasonable. You told them to go on with the transaction. And when they now levy their charge, you say they have stolen your money. That is why the Court of Appeal said, look, this is absolute nonsense. These people are not guilty of this. And you, government, made this election with your DIS, so we don't know what you are complaining about.
So this is now where the bottlenecks and the fight begins. Kulaco, the variation, the fee note, that's where now triggers the DCC or somewhere. Enter FIA, enter DCC, enter all of them, charge this and that and that, and then you go through the explanation. I'm trying to bring you through this chronology. Yes.
I think the DCC don't learn, and I say this with the utmost respect. They simply don't learn. This was not a first occurrence of its kind. This case was on all fours with the Daisy Lou case.
Yeah,
completely on all fours. And the DCC were involved there. They had gone through the same cases, the same type of case. The courts, up to the Court of Appeal, had said, DCC, you are wrong. They come across a perfectly identical scenario. They still repeat the same mistake they did with it. You know how the Daisy looked.
Khawala. It was lost this month.
Bojanyana, and then Kantele Ravaria, and then Daisy Luyarinya. Me anong hare khawala ho tswa ha go ema kwa, this is our charge. We go to tswella o ring. O khaole ebe wa khaola ha go sna khaola Daisy Luyere ke bata madi aka ebe go twi that's corruption. No, if anything is government ineptitude, it's lack of
administration.
Ke lack ya hoela tlhoko di procedure tsa yone le sengwe sontle ka boile Daisy Luyere me ya ha re khaola ha ra go charge yana go ema kwa gore benta ba renya ha ile re letsa ka go ema ngone ho. So the DCC simply don't learn. This was not a face, it was just history repeating itself. And the cases were perfectly identical in the manner in which the two companies charged, Daisy Lou and Kulaco.
So speaking about that, since we have identified who the characters were there, the Israels, Bodignia, Kulaco, and all of that, what exactly was the prosecution's case? What exactly were they alleging, and what were they putting before the judge? Because I want to understand the architecture of what their case was.
It's a good question. But to tell you that I have a really direct answer to it, I would be lying. The prosecution were completely confused, and I say this with the greatest respect. Because, you see, at first, remember, Kgosi Bakang never charged you. And it took like 2 years. After 2 years of running battles in the courts, Kgosi. That's in one more. Meanwhile, Khurumenta hitile contract. Is Office of the President. Yeah, Office of the President. Contract. I have the contract, by the way.
When Kgosi was the Office of the President was Khama. Oh, you mean who?
No, the Office of the President. Okay. And I say this with due sensitivity too.
No, it's fine. We've established that.
Now, yes. This is what the contract says. This is what the contract says. contract between Dignia Systems International and the Office of the President of the Republic of Botswana, represented by the DIS. So the Office of the President had been the contracting parties towards the use of the 250 million. I'll give you a copy of the contract any day if you ask for it.
I want it.
We actually produced it.
I think I have a copy, but I want it again.
We actually produced it in court. It's part of the court records. And these are the kind of things that baffled the Court of Appeal to say, what is this?
Let's deal with that aspect for a minute. So there's all this runaround happening in the while the PSP or someone at the office of the president can say, no, don't arrest these guys, don't run around this. We have this contract, it's highly secretive, and someone decides that they are going to keep it. For what gain and for what benefit?
On the 4th of December 2017, a day after Bakang arrest you, they were arrested on the 3rd. A day after I arrest you, in between my running around, Kibabata Toronko lady, all these places, I went to the DIS offices, Harry Botswana. Kgosi was still the director. I met with Kgosi personally because I wanted to understand what on earth was happening. We sat down in his office, and I'm like, Mrena, what on earth is happening here? Because my understanding is that this is your contract. And I will tell you precisely what he told me in that meeting. It was only the two of us. He said the DCC unquote. You know what I'm saying?
Yeah.
So I left Kgosi's office then, safe in the knowledge that this whole thing was going to be corrected. But Gavi can be quite complicated, Brian. Because that's not what happened. The next thing, we were in court. After all the conversation we had. So, and sometimes it's inexplicable. So, if you ask me, for example, Kgosi Ngakaagae in a or we still don't know why never hitile contract. Should I even tell you how we got to know about that contract? This is how by hitile until the last moment. This is what happened. Only when Kgosi was charged did he produce the contract in his own defense.
What?
I swear on my mom. Only when he was charged did he produce the contract. In the meantime, my clients had been hauled through the courts. But Maruri, Jahori, my dear, Adues Janko, Kabila Honal contract their systems. Who did it like this? I can do Mati. Heart and Namo boxing.
I remember. That fact I know, but what I want you to tell me, because you are dealing with all of them, what is their explanation to you about that? Because you've engaged with Bakang, you've engaged with the ministry, you've engaged with Kgosi, you are busy running around helter-skelter trying to defend your client, when all along Kgosi can come to your office and say, no, vale ba pek. And then
I'm the one who had actually gone to his office.
To his office. And then he says, vale ba pek. And then he doesn't help you to stop this noise, because it's also affecting his office anyway, and it's also affecting government's reputation, it's also affecting the legal. Why doesn't he produce it to you and say, or not even to you, or to the prosecutors, and say, guys, we are the ones who procured this thing, just stop with this? Why does he only then wait for when he gets charged to use it to remove himself?
We didn't even know the contract existed.
No, the question I'm asking is, what then after that did they say to you that we don't know in the background? Because now you are obviously angry.
I asked those questions the entire time. I asked them in court, I asked them in letters, but no one was willing to give an explanation as to what had happened. Because
even after
the
producing of the evidence.
Even after. You see, for my part, I was just happy the evidence had been produced. And I could better defend my clients because more truth was coming to light regarding what had happened.
So you never got back to Kgosi and asked him again,
but this is the juicy
what is
part.
this?
No, I couldn't go to him at that point. He had his own lawyers who were, representing him and all that. The juicy part about all this is this contract is produced in court, or is produced ahead of court.
Of course.
Now, in the defense,
part of the founding affidavit.
Yeah, in the defense of Kgosi.
Yes.
And it actually speaks directly to the contracting party being the office of the president. And in the meantime, we had been trying our best. Remember, the office of the president, the DCEC that were prosecuting were under. And the juicy part is, we did come to learn that on the 2nd of December, a day before, Bakang were arrested. There was a tripartite meeting between the office of the president, some official from the Ministry of Energy, and not the office of the president, the DIS, the DCEC. The DCEC had gone to the DIS on the same issue. So they sat with Kgosi. They sat with the Ministry of Energy. This was the point. This is a day before Bakang are arrested. This is the point where Kgosi could have said, you guys are crazy. This is our transaction. But that did not happen.
Why?
This is, at least now I have to give you my perception, because I wouldn't know precisely why they would. Bobby K have charged an amount, 20% of the, and they said the money would be deducted.
Okay. What became the precise figure? 89 million or so?
No, it wasn't 89 million. It was, in fact, 40 million.
40 million, yes.
Yeah,
yes,
it was 20%.
Yeah, I wanted us to get it in perspective.
Yeah,
it
was 40 million. So they charged 40 million, and they said the money would be deducted from the capital amount, and they had been told, fine, you can go ahead, crack on with it.
Capital amount meaning that we deduct first before you guys do your thing. Before
trust account. Mo trust account nya me ha o tsentse madi ke ituela pele before ke duela le ba ba kolotang. Ha lo re go a thaelwa go ta thaelwa ba ba kolotang that's the way we work in the legal profession. So that is precisely what they had been, how they had been authorized.
So then it is clear that it's coming from the capital amount. Yes.
So the money was coming from the capital amount. But the point I'm trying to make, there had been a meeting on the 2nd. No one wanted to correct this. And you were asking me, but why? And I said, I'd give you a supposition. These guys find themselves with a situation where Bakang have charged an amount which to some people was somewhat astronomical for the services that were being rendered. 20%, 40 million for the services that were being rendered. Now,
yeah, they were citing the usual principle.
They were citing the usual where the industry would have asked
yes,
for this amount and not the 20% that you had asked for.
Yes.
These guys now have to account to the general public for how did you allow someone to charge this much for this kind of work? And they don't have the answers. So the only thing they can do is to deny Bakang, to say, no, we didn't authorize that. They stole the money. But the paperwork, needs. But they still won't give up. The paperwork, needs. All these are the reasons that came before the Court of Appeal. And the Court of Appeal said, guys, because you authorize this. Lona, contract is not about morality. If I agree
it's
with
about
you,
what you
it's
agreed
what about
on.
you agreed on. If I agree with you that kita hwagela one room ka 20,000, you can't then
You better build
tell
it.
me yeah, me the morality but the one room ka 10,000. No,
better build
it's
it.
what we agreed on, regardless of the morality of it. And that's precisely what the Court of Appeal minded government about. And that is the same principle in the Desilu case.
So let me pause there for a minute. When Bakang was signing this contract, let's just say they are business people. I mean, you throw your figure according to how you see your things and whatnot. Then you expect the guy who's receiving the quotation to do their own due diligence because the money is coming from them to say, this level of amount of money coming out of here, 1, 2, 3, and 4, and what are the principles? And at the same time, can I negotiate? Can I whatnot? Why do you think that it was just left to no scrutiny and not passing through a litmus test? Look, they
were under pressure from the DIS to pass the transaction, and they overlooked a lot of things in the
Who was under pressure?
No, the ministry.
Oh, the ministry is
yeah,
the one that was under pressure and
DIS.
overlooked.
Actually, in one of the affidavits, o sign this authorization, which is a disputed version. The minister then were on the phone.
Disputed meaning that they are denying that. They are denying it.
They are denying that. You know, Arwe sign no, it's on affidavit saying that o sign le gore ba mo mogaleng a tshwere mogalana go na le motho a DIS ha go te signa e le gore motho a DIS o tisitse dipampiri. He's all on record. That is his explanation for having signed. He doesn't deny the fact that he signed.
Maybe you should have said a gun. I mean,
yeah, maybe
a phone. I mean,
precisely. Precisely.
So,
yeah.
Then I'm mind baffled to try to understand that. How do you arrive at that? I mean, whoever is charging, can I cab driver or can charge 200 pula? I have no choice. You get what I mean? Me ha go le motsegare ke 30 pula, then I take the 30 pula. We so go charges akabatla, then I say, you know what, I need to get home now. I have no choice, my man. I'll pay you. I think you get my analogy. No. Is it that kind of scenario where you are so under pressure to get your deal that you rather pay the only guy who will make it happen, such that, you know,
yeah. You know, I doubt that they even paid much attention to the issue regarding the amounts, because the letter was there. They must have read it. But from at least what Reuba can see, I don't know if it is true or it is not, they are disputing it, there was so much pressure to sign. And the pressure must have made this whole...
Did he explain the pressure beyond this cell phone?
Gone ga rongwa mongwe gore a te go tsaya lekwalo mme e le DIS a tsena go ofising ya gagwe a tla go tsaya lekwalo mme a re ha motho a le go a letsa borre Kgosi le borre ke bona mo officing ya PS,
which they are denying. But proceed.
Me ba bua le Reuba ke gore motho yo a tswe ho ka lekwalo leo
with this terms and conditions.
Re ke bona according to Reuba ke re ke bona ngona le ko maung on some government mission. Ha ke tswe re Kgosi ene go hona le una le ko kae. So are ke one mabaka. No, there was no gun, there was no knife to the throat. In a hela hore, according to Reuba ke Mbotsadi, bo mail under pressure, which is, like I said, a denied version. They are denying that completely.
But before I move on to the next phase of all of this, then what becomes your conclusion of this strange, because things don't add up. clearly, from the chronicling of how things went wrong, Bakang were being given instructions. The man was not theirs. They were supposed to do as per what the client's requirements are, and the letters were there, I get it. But then the client seemed to have been under pressure from something to make sporadic decisions. And then there is a variation where we are moving from strategic issues of storages to other issues of terrorism and counter-terrorism. What do you think was happening between government and DIS?